Court arise if able. This is an appeal in the matter of the claim on the application of Tasib and Tasib State for the Northern Partner.
Yes, Mr. Butler.
Thank you, my lord. I appear with Mr. Halim, Mr. Dunlop, King's Counsel, and Ms. Williams appear.
Yes, good morning.
Respondent. The appellant and his wife are going to be watching by live stream.
Yes.
I'm told that his father and sister will be attending in person later this morning. My lords, there's the matter of the respondent's notice and the application for relief from sanctions. Can I make it clear that there's no objection any longer on our side to the admission of the respondent's notice?
Well, that increases our store of knowledge. We'll decide that matter in due course. But of course, we're going to hear the arguments about it before we decide.
Yes.
Whether formally to admit it,
of course,
or not. But that's.
I just didn't want to take up time at the outset in what's quite a tight listing,
right.
with arguments about relief from sanctions.
Well, first, it's not relief from sanctions. There are 3 cases in this court that says it's not relief from sanctions. The same approach, and you go through the 3-stage test, but it's not an application for relief from sanctions, just for future cases.
Yes.
They also didn't run it below, and they'd have to be permission to allow a new appeal, but that's another issue.
Yes, I mean, I think the court has its own interest in this matter, and but when we come to that part of the argument, we'll give further thought to this.
Yes, and then the final housekeeping matter, at least for my part, is that there is a supplementary clip of authorities that we've prepared. It's not a swathe of additional case law, but rather a few supplementary bits of legislation and so forth. If I might hand those up.
Thank you. Are they in electronic form?
No, but I can get that
All
sent
right.
through.
So it doesn't matter, it's just so I don't look for them and not find them.
Unless there are any matters from the court at this stage.
Well, only just a broad prospectus of how you both see the hearing going forward.
Yes, we've agreed that I will endeavour to finish my submissions by 3 o'clock today, the respondent by 12:15 tomorrow, with 45 minutes for reply.
Okay, let's see how we go.
Thank you. As identified in the skeleton arguments, there are 4 issues. Issue 1, when do deportation-related reasons allow the Secretary of State to use the authority to carry scheme to prevent the return of someone who has ILR? Issue 2, did Article 8 apply to the ATC decision in this case, and was it breached? Issue 3, if the appellant wins on issues 1 or 2, should the exclusion decision be quashed? And issue 4, was the Secretary of State empowered to make an exclusion direction, as it was called? So if I might dive straight in on issue 1, the meaning of paragraph 14F of the ATC scheme. Now, I understand the court looked at the governing act.
Yes, I mean, we're quite familiar now with the scheme, having heard arguments of different nature about it.
Could I please, though, make 2 points about the governing act that you were shown yesterday? This is in Authority tab 6.
Yeah. Well, thank you for the bundle. The electronic bundle doesn't have tab numbers, so.
Page 78, if I may.
Thank you.
One sees there, section 22, subsection 7, the scheme doesn't determine whether the individual is permitted to enter the UK. And so when the ATC decision was made in our case, the appellant had indefinite leave to enter and remain in the UK, and he kept it for a further 9 months after the ATC decision was made.
And the relevance or significance of that?
I'm going to make submissions
okay.
about that when we get to Article 8.
Okay.
My second point about the statutory framework relates to the level of parliamentary scrutiny of the scheme. Page 79, section 23, subsection 1, a scheme comes into force in accordance with regulations. Subsection 2, the Secretary of State can only make such regulations if the regulations and the scheme were laid before Parliament, and both houses have affirmatively approved the regulations. If you could please look at the explanatory notes to section 23, which are at page 85. Paragraph 109 explains that section 23 ensures that the scheme is, quote, subject to direct parliamentary scrutiny. Second line, paragraph 109. Although Parliament is asked affirmatively to approve the regulations rather than the scheme that accompanies them, in my submission this is close to the highest level of scrutiny for a delegated instrument. And in my submission, the form of scrutiny reflects the potentially draconian consequences of a refusal of authority to carry. Take an individual with indefinite leave to remain and to re-enter the UK, who goes away on business for a few days. He packs his bag, checks out of his hotel, travels to the airport, he has ILR, he's back in the office on Monday, looking forward to seeing his wife and children in the meantime, but he's told at the airport when trying to board the aircraft that he can't travel. In practical terms, or at least the Secretary of State hopes, it's now impossible for him to return to the UK and enjoy his ILR, with the consequence that he may be separated from his wife and children, he may lose his job, he may have no means of accommodation or support in the country to which he was away on business. Now, given those potentially severe consequences, and given the form of parliamentary scrutiny, in my submission one would expect the scheme to be drafted with care and precision, and in my submission it should be interpreted by this clause with a degree of rigour.
So sorry.
And I observe that Parliament has imposed a significantly higher level of control over the ATC scheme than over the immigration rules. One can see that at Authority tab 1, page 9, no doubt this will be familiar, section 3, subsection 2 of the Immigration Act 1971, the Secretary of State must lay the rules before Parliament. Either House may make a resolution to disapprove the rules, and the Secretary of State must then make any changes to the rules that appear to her to be required, and the rules remain valid in the meantime. Now, in relation to the immigration rules, the House of Lords, I think it was the House of Lords, said something about interpretation in the case of Mahad, which is Authority tab 17, Supreme Court. One of the questions was the approach to be taken to construing the immigration rules. Page 303, if I may, part of the judgment of Lord Brown, with which the rest of the justices agreed. Letter B on page 303, the rules aren't to be construed with all the strictness applicable to the construction of a statute or a statutory instrument, but instead sensibly according to the natural and ordinary meaning of the words used, recognising that they're statements of the Secretary of State's administrative policy. And then letter D, true as I observed in the MO case, the question is what the Secretary of State intended, the rules are her rules, but that intention is to be discerned objectively from the language used, not divined by reference to supposed policy considerations. That's in relation to the immigration rules. In my submission, the meaning of the ATC scheme must similarly be discerned objectively by reference to the natural and ordinary meaning of the words used in context. The only qualification in my submission is that the higher level of parliamentary control over the ATC scheme means that it should be construed in a way that comes that much closer to the interpretation of a statutory instrument. If we could then please turn up the 2023 ATC scheme, which is at tab 8, page 94. This is the scheme that was applied in our case. It's the third ATC scheme that's been made under the 2015 Act. The previous versions were made in 2015 and 2021, and we've included those in the additional authorities clip that I handed up this morning. Page 96 of the 2023 scheme. The scheme identifies the context in which it's made. No doubt the court's already looked at this. Paragraph 2, in the context of the ongoing threat of terrorism. Paragraph 3, in the context of the Secretary of State's powers of exclusion and deportation. Paragraph 4, in the context of the visa regime. And overleaf paragraph 5, in the context of the electronic travel authorisation scheme. Then paragraph 6, the overall purpose of the scheme is to prevent certain individuals from travelling when that's necessary in the public interest. The crux of the scheme for our purposes is paragraph 14 on page 98, those for whom authority to carry may be refused. And I propose to focus my submissions on paragraphs E and F.
Sorry, just an oddity. I didn't notice this when we were looking at it yesterday. Authority to carry to the UK is underlined. Is that the case in the original, or is that...
Yes, that's the case in the original. And then one's got a paragraph 15, authority to carry from the UK.
Oh, I see. Yes. Thank you. I just hadn't noticed.
Yep.
So sorry. Do go on.
Paragraph F of 14 covers 3 distinct situations. The third category, who were subject to deportation proceedings but left the UK before those proceedings concluded, was introduced by the 2023 scheme. The others were present in the 2021 scheme. And the Secretary of State in our case concluded that the appellant came within the second category.
What does deportation proceedings refer to in the third category?
I'm going to come on to make the submission that it applies to the entirety of the deportation process, unlike the second category.
Sorry, just tell me again which is the one that came in. What were the dates in which the 3 categories came in?
So E has been there since 2015. F category 1 and F category 2 have been there since 2015. F category 3 was introduced by the 2023 scheme.
Yeah, thank you.
Now, by way of overview, I propose to make 4 core submissions about paragraph 14. The first is that 14F has to be understood against the statutory and policy framework for deportation. Under that framework, deportation is a multi-stage process. Now, 14F applies to both automatic and non-automatic deportation. In non-automatic cases, there are 3 stages. The Secretary of State first decides whether deportation is conducive to the public good. In other words, whether the individual is liable for deportation.
Hang on 1 second.
Is that section 3.5?
Yes, I'm going to come on and show the court provisions. I just wanted to give an overview at this stage of where I'm heading. The first stage of non-automatic cases is deportation conducive to the public good? In other words, is the individual liable to deportation? Second, the Secretary of State decides whether it's appropriate in all the circumstances to make a deportation order. And then third, in a non-automatic case, she has to allow the individual to exhaust any right of appeal to the tribunal before she can make the deportation order.
sorry, you're probably coming to the detail. The logically necessary in that is that she has to do something against which he can appeal.
So she makes a decision to make a deportation order, which generates the right of appeal.
Is that not helpful to have that as as an independent stage to analyse in the interest of clear analysis?
I'd compressed it as part of the second stage. One can break down the second stage into a proposal, representations, decision. So one could divide it into 4 stages.
Well, the second stage in terms of procedure is a decision that it is a communicated decision that it is appropriate.
Yes.
Yeah.
You're going to show us the appeal provisions, because I thought no, it was just an appeal on human rights grounds, i.e. you make a decision, you make an order, and you've got no appeal against either, but you may, if you're the individual, make a human rights case, and the appeal is against the refusal of that. But you just said you had an appeal against a deportation order.
The point at which the effect of the decision to make the deportation order is the rejection of any human rights or refugee convention claim to stay in the country. And so it's the decision at that point which generates the right of appeal to the tribunal.
Against the refusal of the human rights claim.
Exactly. But in terms of where it comes in the process, it comes at the decision to make the deportation order stage, not at the making of the deportation order stage. But we can look at the detail in due course.
I see exactly why you're doing this, but I think it becomes complicated without looking at the provisions.
Yeah.
But
Yes.
still.
Because I also think you can make a human rights claim after a deportation decision. Say, sadly, your wife has died and you're looking after a child, and that is treated by the Secretary of State as if you're asking for a revocation of the order, but on appeal, it would be an appeal against a human rights claim refusal. And it's not helpful now to refer to other things being the subject of an appeal when they're not. But anyway.
I respectfully agree.
Yeah.
In automatic cases, there are broadly 2 stages. The Secretary of State first decides whether it's automatically deemed conducive to the public good to deport the individual. Again, that's a question of whether the individual is liable to deportation.
Well, isn't it more than that? Is he a foreign criminal, i.e. 12 months, not a British citizen? And is there any exception to...
In my submission, stage 1, the first question is he liable to deportation? And that is simply, in most cases, as my Lord identifies, the question, is he a foreign criminal?
So the exceptions don't come in
Don't come in at that point.
Yes,
don't come into the question of whether he's liable to deportation.
Okay.
Second, she must then invite representations and consider and decide whether any of the exceptions to automatic deportation apply.
Yeah.
Until all the stages have been completed in an automatic case or in a non-automatic case, it's not known whether or not a deportation order will be made. The expression deportation proceedings in the third category must mean something different from making the subject of a deportation order in the second category. And as I indicated a moment ago, in my submission, category 3 covers the entire deportation process. By contrast, category 2 covers the process of making the order once it's been decided that it should be made.
Sorry, say that again. The process of making the order once you've decided to make the order.
Yes.
I know you're going to go through this in more detail, but just as a foresight into that, what would the second category cover? What situation would it cover?
It would cover Well, it would cover it wouldn't be a very long period. It might not cover very much time at all. But the period between the Secretary of State determining that a deportation order should be made in a automatic case because none of the Section 33 exceptions are applicable, and then the making of the order.
So it'd be like, I mean, by analogy, the period between a judge finishing a judgment and saying, that's my decision.
And sealing the order and sending it out.
And the sealing of the order, a purely administrative period.
Yes.
And nothing, which, depending upon circumstances, might be a tiny period of time or something a bit longer.
Exactly.
But essentially, on your reading, an entirely residual category.
Yes, that is my submission.
Yes, that's to understand. I wanted to see whether there was an area which was, in a sense, a substantive category, whose process I didn't understand. But
No.
you've clarified.
And that's why one can infer the third category was introduced in 2023. Because the third category, my submission, does cover the entire deportation process.
When you say process proceedings, it's different proceedings. One often thinks about legal proceedings.
One does.
And one way of reading F is to say you've made the order, you're about to make it, or you're in legal proceedings to do with deportation, you've got a human rights claim and you up sticks and you go. The word proceedings has got to have some meaning as well.
Well, sorry.
Well, that was my initial reading of that too, if I may say so. That I read the word deportation proceedings as relating to legal proceedings, because that's often how proceedings are used. But it's not, of course, the natural English language meaning of proceedings. And what, in my submission, indicates that it's not limited to legal proceedings are the words who were subject to deportation proceedings. Now, if an individual brings an appeal against a proposal to remove them from the UK, it's not really apt to describe them as being subject to those legal proceedings. They've brought the legal proceedings.
Well, I don't know, I mean, you detain somebody who's deported, they're supposed to leave the United Kingdom, but they don't. So you detain them and then you put them on a plane. I don't know whether you call that removal or deportation. And the deportation proceedings could cover that.
But that would then be OTOs, because one would already have the
order.
The order. I suppose that what my lord might be saying that, of course, one becomes liable to detention from the moment that one is liable to deportation.
But the other thing is, even though you say the government chose category 2 here, and if they made a mistake, that on their own heads be it, you would say. But if in fact subject to deportation covers everything, the fact they've used the wrong label doesn't seem to matter.
No, and I'm going to make my submissions as to why we don't come within category 3.
Oh, okay.
Could I just ask if you're going to make submissions later about the premise of the submission you just made, which is that deportation proceedings in category 3 must mean something different from the process of making a subject of a deportation order in category 2.
Yes.
Of course, it's slightly clumsy that a different phrase is used, but is it not possible that the phrase "or who were subject to deportation proceedings" is merely meant to mean people who were undergoing the process to lead to a deportation order, i.e. who would otherwise fall into category 2, but who've left the country.
Well,
So the real sting is but who've left the country before the process is complete.
The leaving the country before the process is complete is, in my submission, very important for reasons I'm going to go on to.
Yeah, obviously.
But even on that premise, the third category would add nothing to the second.
Well, maybe, but at the moment it was important. You started your submission by saying, as if it was self-evident, that deportation proceedings must mean something different from the process of making someone the subject of a deportation order. And I see why you make that submission, because different words are used. But I wonder whether that may be being nice that in fact they're intended to refer to the same thing, and all that 3 adds is the fact you've left the country.
My submissions aren't limited to the linguistic point. The
Right,
reasons I'll
thank
come
you.
on to.
Is it possible that 3 is to do with is to scoop up people who've been made subject to a deportation order and have then challenged it through tribunal proceedings, and that it's designed to show that even if you've got into the tribunal, you're within this, and put that beyond doubt. That seemed to me to be a possible reading of it. But
Well, it could only be A for the avoidance of doubt provision, because that individual would
Well,
already
it would mean. I mean, you've had a deportation order, so you come under 1. You've appealed by some means. I take my lord's point, but you've raised a human rights claim, and it's before the tribunal. That doesn't save you on this reading on avoidance of doubt principle. So the fact you take the proceedings and then go abroad doesn't put you in a better position than if you'd just gone abroad without taking proceedings.
No, I mean, but it would be OTOs. It would be a purely for the avoidance of doubt provision. And my submission is not, but I'll explain why.
But I think you made the point, didn't you, that if it meant anything like that, the phrase "subject to" is very odd, because you bring.
I would say that was a nice point.
Yes, right, well, there you are.
A very nice point. Yes.
Well, can I try and rattle through my overview, and then I'll
Right.
perhaps
Well,
try and answer these points?
we'll retire for a while.
This is the problem. This is the problem. I don't blame you, but so often in appellate advocacy, people start with an overview, and the court jumps straight in.
Well, if I jump straight into the provisions, I'm going to
It's
be
been
asked
very.
where I'm
It's,
going.
no,
Yeah, I know. It's insoluble, but there you
it's
are.
been very helpful. Right. So
Second point.
yes.
Second of my 4 overview points concerns the third category in F. Now, I'm going to submit that the significance of requiring that the individual was the subject of proceedings before they left the UK is so that they were on fair notice that if they left the UK, they might not be allowed to travel back. And there was no need for a notice requirement to be written into the second category, because the second category only applies, in my submission, to the final stage of the deportation process, and the individual will, by that stage of the process, necessarily be aware that the process is in train. By contrast, in my submission, the third category covers exactly our kind of case. But the requirement is that the individual has been notified for reasons I'll develop. The third point I'm going to make is that our reading of F is consistent with the statutory framework for deportation. It ensures that the statutory deportation process is completed, including the right to an in-country appeal.
So you say that again? I was just writing down your second point.
Yeah, so I'm going to argue that my interpretation of F is consistent with the statutory framework for deportation, in that it ensures that the statutory deportation process can be completed, including the in-country right of appeal, unless the individual has made an informed decision to leave the country and bring the process to an end.
Hang on a second.
While we're taking that in, can I thank Mr. Halim for arranging the bundle, which has now reached me in good order.
Thank you.
And you say informed decision, because that is the product of your second submission.
Exactly.
You don't actually get that directly from the language.
No.
Yep. Okay.
And it's also significant that there's already a statutory framework for protecting the public interest pending the completion of the deportation process. And that is the scheme for detention and immigration bail.
Is this Still part of 3.
Yes. And then fourth and finally, I'm going to say that paragraph 14E also offers a clue as to the proper interpretation of the second category of F. Now one sees that E bites in 2 situations. First, where an exclusion decision has been made. Second, where the Secretary of State is in the process of making an exclusion decision. Now, before Parliament made the 2023 scheme, the Secretary of State issued guidance on the meaning of the second category of 14E in relation to the 2021 scheme. And that guidance said, and I'll show my lords in due course, that the second category of E only applies to the final stage of the decision-making process. That is, once immigration officials have considered any representations from the individual and they've made a recommendation to the Secretary of State. E, therefore, doesn't apply to the earlier stage at which the individual may be invited to make representations on whether it's appropriate to make an exclusion decision. And I'm going to submit that it would be anomalous to treat category 2 of paragraph F differently from category 2 of paragraph E.
Yes, this is obviously dependent on on what we'll call E2 being using exactly the same language, or the language or process of making a decision. Is it relevant that that language is also used in D? I hadn't spotted till you pointed out that this phrase is used elsewhere than in F. But in that case, one needs to look at all the places. In principle, one needs to look at all the places it's used because you expect it to have a statute, as you were saying, the identical concept lying behind it.
Yes. I'm afraid I don't have submissions to make on D. The reason I propose to make specific submissions on E is because there is guidance dealing with that point.
I see that, but still, I really, all I'm flagging up is that we and or Mr. Dunlop might want to just look at all the uses. It may well be that we get nothing more out of its use in D, but it's there anyway.
We'll have.
Okay, thank you.
Yes. So if I may then, with that said by way of overview, if I could develop my first point. And if I could start with the statutory framework for making deportation orders. Authority tab 1, page 10. Section 3, subsection 5 of the 1971 Act, a person who isn't a British citizen is liable to deportation from the UK if the Secretary of State deems his deportation to be conducive to the public good. That, in my submission, gives the Secretary of State a broad power to determine what's conducive to the public good. It covers criminal conduct, but it also covers a range of non-criminal conduct. The Secretary of State has published guidance indicating that she may consider it conducive to the public good to deport someone who's entered into a marriage of convenience, who has evaded customs duties, or on public health grounds.
What was the third one?
Public health grounds.
So this contemplates two things. Firstly, the Secretary of State must deem the deportation to be conducive to the public good. I don't like this chap anymore. He's committing crimes. And if that is what the Secretary of State decides, then he can be deported.
3F is deciding that he is liable to deportation and no more in my submission. Page 24.
Hang on. Just one more point. You say you gave various examples from the Secretary of State's guidance. I'm not asking to be referred to it now, but which guidance is that? Guidance specifically on Section 3.5, is it?
Yes, there is. I'm going to show the court in due course the guidance on criminal conduct and when that makes it conducive to the public good. And that guidance cross-refers to a separate piece of guidance which deals with non-criminal conduct like public health reasons. We haven't got the public health reasons.
Well, no, I wasn't asking. I just wanted to. This is published guidance, not specifically about deportation.
Specifically,
I had at the back of my mind. I see. It is specifically about deportation. Yes, I see. I had at the back of my mind that there is quite a lot of guidance about the general grounds for refusal of leave to enter or remain in the immigration rules.
that's not what I'm referring to.
No, I see. Okay, thank you.
I'm having trouble with 3.5.
Yes.
3.5 doesn't say the Secretary of State may decide that a person is liable to deportation. Section 3.5 says the Secretary of State may deem his deportation to be conducive, and a legal set of consequences arise from that, i.e. in the context of an act where we've just seen right of abode and leave to remain, you're liable to deportation. You may be taken out of the United Kingdom. So the Secretary of State isn't deciding that a person is liable. The Secretary of State is deciding that deportation is in the public good, and if that's what he's decided,
Then the person is liable.
then he's liable.
Yes.
Yes.
Yes. Sorry, I was imprecise in my language. I respectfully agree.
Great. Good. Fine.
When we then get to page 24,
So
Yeah.
one last tiny point.
yes,
I've never thought about this before. Deeming, it's an odd use of, it's an old-fashioned use of deeming. It just means judges. Or,
Yes.
Yeah.
yes.
Not deeming in the sense of contrary to the fact. Yep.
So that establishes liability to deportation. And then page 24, section 5, subsection 1, where a person is liable, the Secretary of State may make a deportation order against him. So in my submission, there's a distinction between a
So
decision.
sorry, where have we gone?
We've gone to page 24,
Yep.
section 5, subsection 1.
Okay, thank you.
So in my submission, there's a distinction between a decision under section 3 on whether it's conducive to the public good.
There's a
and
difference between a decision that it is not conducive to the public good that you remain in the United Kingdom, and a deportation order, which is a legal instrument which has specific consequences attached to it.
Section 3 in my submission, the section 3 decision establishes liability to deportation. The section 5 decision establishes whether or not a deportation order should be made.
Those words need to be looked at carefully. Section 3.5 says that where the Secretary of State decides that deportation is in the public good, i.e. is conducive to the public good, then he is liable.
Yes.
That's the decision, not a decision that he's liable to it. It's a decision which has legal consequences, but the thing that gives effect to these legal consequences is the deportation order, because that is the legal instrument that says you should leave, and your existing leave has been cancelled.
Well, the point I'm seeking to make is that there are two distinct decisions.
A decision and a deportation order.
A decision, no. A decision on whether it's conducive to the public good,
Yeah.
decision 1, and a decision in light of that, should a deportation order be made, decision 2.
Well, it's actually a decision on whether conducive, and it's the making of a deportation order.
No, a decision on whether to make the deportation order, because there's a separate decision that has to be made for the purposes of section 5, subsection 1. It's not automatic. It doesn't follow ipso facto from a determination that deportation is conducive to the public good that a deportation order will be made.
No, may make a deportation
Yeah.
order, but the legal instrument is the deportation order. There's not a decision, it's conducive, a decision to make the deportation order and the deportation order.
Yeah.
There's a decision that is in the public good, and there's a discretion as to whether or not to make a deportation
Yes,
order.
yes. And the exercise of that discretion in my submission constitutes a decision.
Yes, in fact, neither provision uses the word decision.
No,
Yeah.
no.
But you're saying in public law terms,
In
they are
public law
both
terms, a
decisions.
decision has to be made.
Yes.
Now, I watched some of the proceedings online yesterday, and Mr. Malek, King's Counsel, told the court that a deportation order can't be made once the person has left the UK. Now, that in my submission is incorrect. In the bundle of additional documents that I handed up, there's one authority at tab 6, which is the Court of Appeals judgment in a case called Decker. And I think it's sufficient to look at the holding in the head note to see that the Court of Appeal decided that a deportation order can be made when the person has left the UK.
So again, I'm being rather slow. This is in your new bundle.
Yes, it is. Tab 6, page 129. And one then gets the detailed reasoning if you want to see it at paragraph 29.
Hang on. Sorry, you were taking this rather quickly. You took us the head note first.
Yes, if I would perhaps just read where it says held allowing the appeal in part.
Yeah.
The subject's presence in the UK isn't a precondition to the making of a valid deportation.
Yes. And then you say you find more of the detailed reasoning of that at 29.
Yes.
Do we have to read the whole of 29? Does 29.1 merely,
Well,
right?
what one gets is at page 134, at paragraph 22, we get a list of the claimant's arguments.
Yeah.
And then at paragraph 29, we get the Lord Justice Hamlin's response to those arguments, point by point.
And that's all he says.
Yes. But the punchline in my submission is there's just no limitation in the Act. Nothing in the Act that says the individual has to be in the UK to make the deportation order.
No, I asked Mr. Malek,
Sorry.
in the context of subsection 535, but you're right to say that only describes the state of affairs that follows from a decision about conducive to the public good.
Yes.
The state of affairs being is liable, it
Yes.
doesn't require him to be in,
No.
is your submission.
Yes, that's my submission. Well, and I say that there's binding authority to that effect.
Yeah.
Well, I suppose, okay, it's binding authority. I still, with great respect for Lord Hamlin, I don't quite understand it. The argument he's meeting is a deportation of its nature is an order that someone leaves the country.
But also that they can't come back. Also that their ILR or other leave is cancelled. And also that they'll never be granted entry clearance. Or
Well, those are consequences of a primary order, which is leave the country.
Yes.
You,
well,
okay, but
the way-
there's no point. There's no point arguing because there is, as you say, binding
Well,
authority.
I'm not sure I'm finding it as difficult to see why this is said. I mean, in paragraph 22, the argument was squarely put, you can't make a deportation order against me because I was in Ireland.
Yeah.
And 27, 28, 29 in particular, the fact that it would be ridiculous if you could avoid making deportation orders simply by going to Ireland for the day.
yes.
Yeah.
It seems
My
to be
incredulity is probably wrong, but in any event, we're stuck with it. Even
Well, I don't. I was only separating myself from the thought that we were stuck with it. I mean, we're clearly bound by it.
yes. Better way of putting it.
Yes. All right. Well, since the Secretary of State is permanent and indivisible, if there's a disagreement about that, then we'll hear from.
I don't think
next
there is
counsel.
because Decker is referred
It doesn't
to
seem as if there is. So
no.
That
Decker's referred to in a footnote of my learned friend's skeleton argument for this proposition.
good.
So,
All right. Good.
well, Could I come then back? I've referred to the deportation process by reference to sections 3 and 5 of the 1971 Act. Could I please now show how the position is modified in automatic cases by the UK Borders Act? That's in the authorities bundle at tab 5, beginning at page 70. So section 32, subsection 1, a person is a foreign criminal if certain conditions are satisfied, and those include where, subsection 2, he's been sentenced to a period of imprisonment of at least 12 months, as in our case. In relation to a foreign criminal, subsection 4, deportation is conducive to the public good for the purposes of section 3(5)(a) of the 1971 Act. Although, as I'll show, my lords, in a moment, that is qualified by section 33. And then subsection 5 of section 32, the Secretary of State must make a deportation order, and that's expressly stated to be subject to section 33. And page 72, section 33, subsection 1, both section 32(4), that's the requirement to deem deportation to be conducive to the public good, and section 32(5), that's the requirement to make a deportation order, they don't apply where one of the relevant exceptions applies. And then working through the following subsections, one sees that there are currently 6 exceptions. Exception 1, where removal would breach ECHR or Refugee Convention obligations. Exception 2, where the foreign criminal was a child when convicted. Exception 3 has been deleted. Exception 4, where the foreign criminal is subject to extradition action, broadly. Exception 5, overleave.
So sorry, just one moment. Yep, sorry, go on.
Exception 5, where the foreign criminal is being detained under mental health powers. Exception 6, where deportation would breach ECAT, the Convention Against Trafficking. And exception 7, where deportation would breach the withdrawal agreement or related provisions. And then page 75, we have got subsection 7. The disapplication of section 32 subsection 4, that is deemed conduciveness, and section 32(5), duty to make a deportation order, the disapplication of those provisions on the basis that one of the exceptions applies doesn't prevent the Secretary of State from exercising her non-automatic deportation powers under sections 3 and 5 of the 1971 Act.
Well, I think what that is saying is, in 7A, is that you might still make a deportation order, even though you're not required to make a deportation order. And 7B, bizarrely, is saying you don't assume one way or the other whether it's in the public good, because you've got to decide that. But section 32(4) says it still applies, notwithstanding you're within exception 1 of convention right. So although it's subject to it, it's put it back. And the way I read it is that it is the 3(5)(a) exercise in an exception 1 case has still been decided. It is in the public interest, it's conducive to the public good to deport a foreign national criminal, even if that would breach his rights.
Yes.
Okay.
So yes, I was going to come and say that, but I respectfully agree. And so what that leaves in that category of case is the section 5, subsection 1 decision. It's conducive. Should I make a deportation order?
Yes. So now, the deeming has been done by Parliament, and the only question then is the making of a deportation order.
Do I make a deportation order? Now, there are also immigration rules which complicate the position. The Secretary of State has said in immigration rules, I'm not actually going to make a deportation order in an exception 1 case, but we don't need to get into that for purposes of statutory interpretation.
No.
Now, the effect of all of that, in my submission, is that the Secretary of State can't know whether she's required to make a deportation order under the 2007 Act unless and until she's considered and decided whether the Section 33 exceptions apply. And the requirement to consider the Section 33 exceptions can't depend on whether the individual makes representations. There's nothing in Section 33 to suggest that the Secretary of State can ignore these considerations if the individual doesn't raise them. For example, if the Secretary of State knows that a person is detained in a psychiatric hospital, she has to address Exception 5, even if the individual doesn't make any representations. Now, as I'm going to show, my lords, when I turn to the guidance, the Secretary of State decides the question of conduciveness by way of what's called a Stage 1 decision. In a non-automatic case, does she consider in all the circumstances that deportation is conducive to the public good? In an automatic case, do the Section 32 conditions apply? Is the person a foreign criminal? And if it's conducive to the public good, she then decides the question of whether to make a deportation order by way of what's called a Stage 2 decision. In a non-automatic case, does she consider in all the circumstances that a deportation order is appropriate? In an automatic case, do any of the Section 33 exceptions apply? If they do apply, should the Secretary of State nevertheless use her power to make a deportation order? Could I then please show, my lords, the...
Hang on. So you say there's 2 parts to Stage 2. Do the exceptions apply? And if they apply, you must make... you must decide whether to make a deportation order.
you go back to the Section 5 question.
Yeah, but if the exceptions apply, by definition, if it's incompatible with the Convention right to remove, you can't make a deportation order. Well, you can make it, but you can't enforce it.
Exactly. You can, according to the Act, make the order.
In the hope that your family life, your wife might leave you, the children might say, I hate you, and then you can deport them. Oh, well, yeah.
That may be a reason to do it.
Effect, yes.
But in, as I
Sorry,
said...
this is a stage which my lord obviously noticed and I didn't. How do you get to the point that even if one of the exceptions applies, you can make a deportation order, you just can't enforce it?
So you are working through Section 33.
Yes.
You conclude, for example, that Exception 5 applies because the person's in a psychiatric hospital. You then turn to subsection 7, and you are told that the application of that exception doesn't prevent you from making a deportation order. It just wipes away the requirement to do so. So you then turn back to Section 5, subsection 1.
Sorry. Yes.
So you then go back. How do you go about deciding whether to make a deportation order? Well, that's Section 5, subsection 1 of the 1971 Act. So you turn back to that.
Yes, but you go back, as you say, to the 1971 Act. But if you have suppose take your case of being detained under the Mental Health Act. Is it conceivable that you could make an order, but what would be the point of making an order?
Well, as my lord said, you might hope that the person recovers.
Well, I did have a case involving somebody who was stateless, and the exceptions applied, but the Secretary of State made the deportation order for a few years in the hope that he would persuade the country that he'd come
Yes.
from to give him his citizenship back, but they were resolute and said, no, you're not coming back.
Okay, all that
And eventually the Secretary of State revoted. So
Yeah.
it was to keep the possibility open, I think.
all that makes sense, but in fact, that effectively produces a third stage in the argument. Do I enforce a third stage in the analysis? Do I enforce on which no guidance exists, unless you'll show us any, but you will have some sort of case-specific reason of that kind. If you do decide, for example, to make a deportation order in respect to someone who's being detained, not they, but their representatives should challenge that order on the basis that it's absurd to make such an order. They say, well, it's an order, but it's an order I don't intend to enforce.
Well, there may be public law objections to the making of the order. What I'm looking at the moment is what the statutory scheme provides for.
Yes, okay.
Now, in answer to my Lord's question, well, yes, there is guidance out there which says, the immigration rules say, we, the Home Office, don't make deportation orders if Exception 1 applies. But they're not required. They're not required by the Act to take that position.
No.
That's something they've chosen to do under the immigration rules.
Yes, okay. Thank you. I think I've got that.
Could I then please show my Lords the deportation appeal provisions? Tab 4, page 59. I entirely take the point that my Lord Justice Lewis made, which is that this doesn't say that the target of an appeal is a stage 2 deportation decision, but it's at that stage that the Secretary of State in practice decides protection claims, human rights claims, and so as a matter of practice, if the Secretary of State makes a stage 2 decision that it's appropriate to make a deportation order, as part of which he refuses an asylum claim or an ECHR claim, then the individual has a right of appeal.
Against the refusal of the human rights claim.
Exactly.
It might be useful to show a Section 79 as well, but it's a matter for you.
I am going to come on to Section
I'm
7.
going to come back to it. Okay, that's fine. I don't want to miss anything.
No.
Yes, it's actually.
And so, yes, so that's Section 82. Then if we could look, please, at page 57.
So the only right of appeal you've got is if you refuse a human rights claim. So if you said
or a refugee claim.
or a refugee claim, but we're not into refugees here.
Not in our case.
No. So let's not get sidetracked. If the person concerned has not yet made a human rights claim, the fact that they might do so doesn't yet trigger a right of appeal.
Yes.
So the making of a deportation order even still doesn't prevent a right of appeal, because he might say, well, hold on a moment, I've got a human rights claim, you can't get rid of me because my wife and children are here. So the human rights claim may come up at any stage, from the day he's first convicted through to as he's being taken to the plane.
My Lord, I accept that.
Yeah.
When we come on to look at the guidance, we'll see that what's contemplated in the ordinary run of case is that this issue will arise at stage
You'd
2.
expect it to, but it needn't.
But it needn't. I accept that.
And for statutory interpretation purposes, it's the Act, not the guidance.
Yes,
relevant.
I accept that. Page 57, my Lord
Sorry,
has already noted Section 79. Subsection 1, in a non-automatic case, the Secretary of State is prevented from making a deportation order either while an in-time appeal could be brought or an appeal has been brought and is pending. And the time limit for appeal, it's not set out here, but the time limit for appeal is 14 days if you're within the UK and you're not being detained.
And that would be a deportation proceeding, would it, for the purposes of 14F?
It would be. I've not accepted the proposition that proceedings in the third category of F is restricted to legal proceedings, but I do accept that legal proceedings would form part of the overall deportation process.
So it would include this, but wouldn't be limited to
Exactly. Subsection 3, this bar, the bar I've just described, doesn't apply in automatic cases. But subsection 4, the deportation order doesn't have the effect of invalidating leave in this category of case.
Hang on. Gosh, I hadn't seen that before. Okay.
So then finally, page 61. This is section 92 of the Act. If you could please look over leaf at subsection 8.
So which page are we on?
Page 62, subsection 8 of section 92. In short, if you bring an appeal from within the UK but leave before that appeal is finally determined, you're taken to have abandoned the appeal. In my submission, one effect of these statutory appeal provisions is that although there's a public interest in deporting foreign criminals, Parliament has determined that it's appropriate to permit foreign criminals to stay in the UK to pursue an appeal. That is, unless there's a basis for certifying the claim, which hasn't been suggested in our case, because they come from a safe country and the claim's clearly unfounded, or because they've only brought a human rights claim and they can safely go back in the meantime.
Sorry, again, I've just been slow. So the effect is what? That
the effect is that Parliament has determined that it's appropriate to permit foreign criminals to stay in the UK to pursue an appeal.
Yeah, but it doesn't deal with that end of the telescope, does it? All it says is here, if they've let you stay here, or if you are here, and it's a human rights appeal, and you subsequently go, the appeal is gone. This is just bringing the proceedings to
I'm
an
so
end.
sorry, my lord. The submission I've just made is not focused on subsection 8.
No.
The submission I've just made is a consequence of the entire
Of the entire scheme,
appellate
okay.
scheme. Could I then please show the court the deportation guidance that was in place at the time that Parliament approved the 2023 ATC scheme, which is at tab 12 of this bundle, beginning at page 112. And if within that, we could please look at page 118. If one looks next to the second hole punch, or where the second hole punch would be, there is a sentence beginning guidance on deportation on grounds of public policy. And it's there that one sees the reference to separate guidance on whether deportation is conducive to public good for reasons relating to things like public health, I referred to earlier. This guidance that we're looking at relates to criminal cases. Then page 122. The last two lines on the page, this isn't an exhaustive list, and deportation may be pursued in any case where the Secretary of State considers that deportation is conducive to the public good, makes the point that I made earlier, that the concept of conducive to the public good is broad, and the Secretary of State's power under Section 3 of the 1971 Act is broad. Page 145. there's a section addressing the exceptions to automatic deportation. So the section 33 exceptions. Overleaf on page 146, there is a subheading, Asylum and Human Rights, and the second paragraph under that heading begins where consideration is being given to deportation. Where consideration is being given to deportation under the 2007 Act, any claim made that the person's removal would breach the Refugee Convention and or that it would breach the ECHR must be considered in full before a deportation order can be signed. And that reflects the statutory scheme. It can't be
Well,
said.
does it? You can make a deportation order even if the exceptions apply. Exception 1 applies. It doesn't reflect the scheme. It's an additional thing.
You have to think about it in order to determine whether you have to make the deportation order under the 2007 Act. And the guidance then explains how the Secretary of State will go about making that decision. Page 157. This explains what's called the Stage 1 decision. The heading is Stage 1 Decision to make a deportation order. But as we'll see, in my submission, that is something of a misnomer, because it's actually a decision on whether it's conducive to the public good to make a deportation order, not a decision actually to make a deportation order. Under the heading Consideration, the first paragraph, if a foreign national meets the threshold for deportation...
Sorry, another way of putting it, using your own analysis, is the decision is whether they're liable to deportation.
Yes.
Yeah.
Exactly. Then under the heading Consideration, first paragraph, if a foreign national meets the threshold for deportation, you must consider making a Stage 1 deportation decision and issuing a Stage 1 decision letter setting out why deportation is conducive to the public good. Now that's accurate.
Sorry, which paragraph was that?
That was the first paragraph under Consideration,
Yes,
if a foreign
yes,
national
thank you.
meets. And then the fifth paragraph begins, you must set out in the decision letter all disclosable information held by the Home Office about the person's circumstances at the time of the decision, including length of residence in the UK, immigration status and any dependents. Consideration of outstanding human rights claims should be deferred until after the person has had the opportunity to make further representations so that all matters can be considered together. So in automatic cases, don't decide at this stage whether exception 1 applies.
This is a matter of guidance. You could, in fact, decide whether exception 1 applies on the information that you already have.
Yeah.
Well, we see why they've chosen not to do that.
No, and this is the reason that I'm showing the court the guidance as it existed at the time the 2023 scheme was made, is that in my submission it forms part of the relevant context and informs what Parliament would have understood the process to entail.
The difficulty that I've got, just so you know, is in this world, goodness knows why, words mean everything, and it's consideration of outstanding human rights claims. And in the immigration world, that has now been given a very specific meaning and a definition in section 113. A person has made a claim that entry or removal or refusal of entry or removal will mean a breach of human rights. So it's not that an exception applies. This is that consideration of an outstanding, an existing human rights claim, i.e. something that has been made within the definition of section 113. It's been made and not yet determined. It doesn't say anything about a situation where no human rights claim has been made, or if it has been, it hasn't been determined. And in that situation, you are just in the act, I think, at the moment.
Yes, I accept that.
Ah, right,
I
okay.
accept that. I accept that it is limited, that paragraph is limited in that way.
Yeah.
Just so I can understand how these things happen in practice, my understanding of how they happen in practice is that although you may, for particular reasons, have an existing claim, classically, you will get a stage 1 letter, and a human rights claim will be is to be expected as a response to
In
the
fact,
stage one
it's
decision.
positively invited, and I'll show the court
And
the
it
letter.
very usually happens.
Yes, and it
But
usually
in this
happens.
case, for example, when we come, because you're going to take us through the decision letter, Mr. Tasib had not made a human rights claim at the time the thing that is called a stage one decision letter was sent out.
No.
So therefore, there was no need to defer consideration of an outstanding human rights claim because none existed.
No, I'm making submissions about the scheme and how the scheme as a whole operates rather than my client's particular case. Then the 7th paragraph on this page, the decision letter must inform the person that they may, if they wish, make representations within 20 working days. So in an automatic case, the section 33 exceptions question is deferred until the applicant has had the opportunity to make representations on those matters. And in the final paragraph on the page, a section 120 one-stop warning should be sent with the request for any representations so that the onus is on the applicant to make all representations that might be relevant.
Yeah.
Then page 160, the heading here is Stage 2 consideration of representations and obtaining the deportation order. If you please turn over leaf to 161, there is a heading towards the bottom of the page, Stage 2 decision to make a deportation order. Paragraph immediately below, if no representations are received within the 20 working day deadline given in the Stage 1 decision, you must consider whether to make a deportation order on the facts before you. And so until the Stage 2 decision has been made, the Secretary of State doesn't know whether or not a deportation order will be made. In a non-automatic case, she may decide it's not appropriate. In an automatic case, she may decide that she's not required to make a deportation order, and she may decide it's not appropriate. Then page 165. Under the heading Obtaining a Deportation Order, the guidance correctly explains that in an automatic case, once a Stage 2 decision to make a deportation order has been made, there's no barrier to making the deportation order. Page 165.
Which paragraph in 165? No
The
barrier.
second paragraph deals with automatic deportation. In short, no barrier once you've made the Stage 2 decision. And then below that, but in a non-automatic case, the deportation order can't be made until the individual has exhausted his or her appeal rights.
So I haven't followed or understood this again. The second paragraph, under the UK Borders Act, a deportation order can be obtained regardless of whether the foreign national criminal lodges an appeal.
Yes. The point I'm making is that it follows the Stage 2 decision. That's all I'm saying.
But I don't understand the next sentence. It's my problem. Section 34(2) of the Act provides the deportation order cannot be made under Section 35 whilst in appeal or further appeal against the conviction of the sentence.
Yes.
So that's nothing to do with the appeal on the human rights.
No.
That's the I didn't do it or it should be less than 12 months.
Yes.
Okay, now I understand it.
And then the next paragraph deals with non-automatic cases and again makes the point we've already looked at. That the deportation order can't be made until the individual has exhausted their appeal rights. Until then, the Secretary of State doesn't know whether or not she'll be able to make a deportation order. So that's what I wanted to show the court in relation to the guidance. Could I then please show you one authority on this, which is the case of AA at tab 41.
Do you happen to know which bundle that's in, do you?
The second of the three authority bundles.
Oh, yeah.
I'm so sorry.
Sorry, if it's tab 41, it's
sorry, it's 41. It's the third.
Right, I'm throwing my bundle.
Third of the authority bundles.
And this is a decision of Mrs. Justice Foster, okay?
Yes, it is. And the question in that case was the meaning of section 259 of the Criminal Justice Act 2003, which one sees at page 963.
Decision which took 7 months to produce.
Oh, I hadn't noticed that.
Page 963.
963, one sees the relevant statutory provisions. Paragraph 52, one sees section 246 of the Act, which provides for the possibility of the release of prisoners on licence. Subsection 4 provides that subsection 1 doesn't apply, where F, the prisoner is liable to removal from the UK. And then at paragraph 53, one sees section 259 of the 2003 Act. A person is liable to removal
Well,
if...
for the purposes of this chapter.
Absolutely.
Yeah,
For the purpose... Sorry, I'm so sorry.
liable, yes.
Absolutely for the purpose of this. I'm not seeking to draw any wider implications. For this purpose, he's liable to deportation. He's liable to removal for this purpose if both he's liable to deportation under section 3.5 of the 1971 Act and he's been notified of a decision to make a deportation order against him. And Mrs. Justice Foster went on to explain the distinction between A, a decision that a person is liable to deportation, and B, a decision to make a deportation order against that person. If we could please look at page 969. If my lords would please read paragraph 78. And then could you also please read paragraph 80.
Yeah.
And so then page 974. If you could please read paragraph 105.
Say the fact that decision to deport either means the making of a deportation order or the decision to make a deportation order. Is that what she's getting at?
Well, she's construing section...
It's the second sentence, the liability to deportation,
yes.
which is the first stage.
Yes.
But a decision to deport,
Yes.
and that means the making of a deportation order, does it?
Yes.
Yeah.
In my submission. And in my submission, this is a correct summary of the process. And as far as we've been able to ascertain, the Secretary of State hasn't sought to appeal this decision. Could we then please turn to the stage 1 decision that was made in our case, which is in the supplementary bundle. Page 122.
Does it actually start at 120?
Well,
Or is that a separate letter?
that's the covering letter, I think.
That's the covering letter, yes.
There's at page 122 that one sees what's described as decision to
So
deport.
sorry, my bundle has turned to bits. Just give me a moment. Yes, 120.
122, please.
Well, sorry, I think it is important to look at 120 because it says in the second paragraph, please find enclosed. Well, the first paragraph, he's liable to deportation. We know that because he's deemed to be conducive to the public good. Then please find enclosed the following documents: a notice of a decision to make a deportation order, which is given a title, and then various other things. So that's what it says the documents following are.
Yes.
Yeah.
And what I'm showing the court is the first in that list,
Yeah.
which is at page 122.
Yeah.
And one sees at the top of the page that it's entitled Decision to Deport.
Yeah.
And then at the bottom of the page, under the heading Part 2, Considerations in your Deportation Decision, one sees what the Secretary of State has decided at that stage. Second sentence, the Secretary of State has decided your deportation is conducive to the public good. In other words, it's a determination under Section 32 of the UK Borders Act.
So sorry. Yes, I see. Yep, thank you.
Well, I just think it's not fair, Mr. Butler, to ignore the first part. Part 1, deportation decisions. It describes his criminal history, and the last part of that paragraph says, under Section 32(5), Secretary of State must make a deportation order in respect of a foreign criminal, unless one of the exceptions apply. And it says, you have not shown that any of the exceptions apply to you.
I accept it says that.
Yeah?
Yes, well, what this means to you, if a deportation order is made,
Exactly.
just coming up.
Yeah.
Well, that I was saving
Yeah,
that. for
no,
later.
exactly. I mean, I think you can take it that we do read the whole page
Yes.
together. I appreciate you're trying to move on.
Yeah.
Yes, but I just wanted to begin.
So sorry,
by-
even before you do that, what you have not shown that any of the exceptions apply to you, but at this stage you've been given the opportunity
been
to
asked.
show.
Yeah.
What do you say? I mean, it may just be as one sees the standard form letters rather ineptly drafted.
Yes, exactly
But
that.
that is inept.
It is inept.
Yes.
The decision that is being taken at this stage in my submission is accurately described at the bottom of the page, which is the passage I was showing the court. The Secretary of State has decided your deportation is conducive to the public good, as set out in Part 1, which is the part that my Lord Justice Lewis referred to. And then by the second hole punch, what this means for you, the point my Lord Justice Peter Jackson noted, if a deportation order is made against you, then you'll be required to leave the UK. And the word if in my submission shows that it's still at this stage uncertain whether a deportation order will in fact be made.
And all these labels, notice of decision, which is clearly how the Home Office categorise it, and then decision to deport, pursuant to the two acts. These are basically Home Office concepts.
Yes.
As we've seen, there's no the statute doesn't refer to a decision to deport.
No.
The only thing it refers to is a deportation order.
Yes.
Yes, I see.
But in my submission, if one reads this letter as a whole, it is consistent with the statutory scheme. Because the Secretary of State is saying, if I decide to make it, still a decision that hasn't been made, and that's consistent with the statutory scheme, the Secretary of State can't proceed to make a deportation order unless and until she's determined whether the Section 33 exceptions apply. And she doesn't purport to have done so in this letter.
Hang on.
Yeah.
And there's more to the same effect over leaf, page 123. The second heading on that page is indefinite leave to enter / remain. Second sentence, if a deportation order is made against you. The next paragraph begins, given your criminality and the risk you pose to the UK, if, despite liability to deportation, there are legal reasons why you can't be deported from the UK, ... And then similarly, page 120.
And that is essentially a reference to the exceptions.
Yes. Then page 124, the penultimate paragraph begins, if you inform us, and perhaps the court might just read that paragraph.
Again, because I'm obsessive, I've stopped at removal from the UK. What is proposed to happen is directions, but of course only if a deportation order is made.
Yes.
And then the one sovereign is the second paragraph. If you wish to provide reasons why you should not be deported,
Yes.
you've got to do so within 28 days. And then if you inform us of the reasons.
Yes, and it was that paragraph in particular that I wanted the
Yeah.
court to read. And I emphasise the fourth line. We will advise you of whether or not your deportation will be pursued.
Yes, and again, if they were using exactly the language of the statute, it would be, we will advise you whether or not a deportation order will be made.
Yes.
Whether it is, well, yes.
You were about to say,
Well, we'll let you know when we've decided whether or not a deportation.
I think decisions are then helpful. There are two things: the conducive to the public good, which triggers the process, and the making of a deportation order. The introduction of the words, the decision to make the deportation order, I fully understand that the making of a deportation order may require a mental exercise that we often use a decision to describe. But there are two stages. Is it in the public good? Are you making a deportation order? And the deeming and the deportation order, it's better to focus on those.
Well, in my respectful submission, whether it's a mental exercise that is not committed to paper, or whether it's an exercise that is committed to paper, a conscious decision has to be made by the Secretary of State under Section 5, subsection 1.
The Secretary of State must consciously make a deportation order. There's no point in spending time on it.
The court has my submission that a decision has to be made. The Stage 1 decision letter was accompanied by a statement of reasons booklet. Now, I'm afraid the ordering has got jumbled up in the bundle. It starts at page 132. And one sees the first sentence.
132.
132. I hope that the court there has something headed Statement of Reasons, which is the booklet that accompanied the letter. And the first sentence, the table below gives examples of reasons why you might think you shouldn't be deported from the UK, and gives examples of evidence that you might want to submit to substantiate your claims. And it then continues at page 126.
Oh, I see, yes.
It's just out of order, I'm afraid.
Yeah.
Now, in my
And runs to 120.
yes, and then carries on to
128.
128.
Yep.
Yes, exactly. And then there's also the one-stop notice, which one's got at page 130. Now, in my submission, the decision at page 122 formed part of the deportation proceedings within the meaning of category 3 of 14F. But it didn't form part of the narrower process of making the deportation order for the purposes of category 2.
I'm so sorry. Could you just give that submission
Yes.
again?
That the decision that we've just looked at page 122 formed part of the deportation proceedings within the meaning of category 3, but didn't form part of the narrower process of making the deportation order for the purposes of category 2. Because at this stage of the deportation process, it couldn't be said that a deportation order would be made. Now, of course, with the benefit of the exclusion decision, we can see with the benefit of hindsight that a deportation order would have been made. But as at the date of the ATC decision, in this case, that couldn't be said to be so. Now, by analogy, if my lords ultimately decide to dismiss this appeal, it will be possible to say at that stage, with the benefit of hindsight, that this hearing was part of the process of dismissing the appeal. But looking forwards from where we are now, it's not possible to say, I hope, that the court is in the process of dismissing the appeal.
I just need to think this through again, actually. Because I'm obsessed with there are only 2 legal events occurring, the decision on conducive to the public good, which is done by Parliament in this case, so that's happened. One of the legal effects of that is liability to deportation. That's the first legal event. The second legal event is the making of a deportation order.
Well, there is a wrinkle in that, my lord.
Yeah, that's why
that
coming
Section
back to it.
33 doesn't only apply to the decision to make the deportation order, it also applies to deemed conduciveness. Because although exceptions 1 and 4 don't displace deemed conduciveness, the other exceptions do.
Yes, but we're not into the other exceptions.
No, but we're into construing the scheme, and construing the scheme requires one to understand the whole, in my submission.
Yeah.
But does that alter things? You've got because it'll be neither one thing nor the other under the first part of subsection 7. I see. Yep, okay, I see what you're saying.
And so the analogy that I'm seeking to draw is with these proceedings. Looking forwards from where we are now, it's not possible to say that the court is in the process of dismissing the appeal, only that the court may or may not be in the process of dismissing the appeal. So too, at this stage of the deportation process.
We are in the process of determining the appeal.
Yes.
But not dismissing the appeal.
No. It may turn out subsequently with the benefit of the hindsight that you were, but you can't say it now. And of course, when the ATC decision is made, it has to do it as things stand at the date of that decision looking forwards. Could I then please try to develop my second point, which relates to the meaning of the third category of 14F. It might be convenient just to turn back to Authority tab 8. Page 98.
So, as we have, as I've had it in front of me for some time now, F, because it makes sense to hear your submissions with it clearly in our minds. In the process of alternative ways of putting this, which might be the same, might be different, considering whom the Secretary of State is considering making the subject of a deportation order. The question really is whether that is meant to mean considering, or whether it means has determined. I mean, that's the range, as it seems.
Well,
to me.
it's the making the subject of. And in my submission, making the subject of a deportation order is making the deportation order.
Yes, but I'm focusing on the words in the process of.
Yes.
I mean, clearly the Secretary of State has got to go through this process in order to make a deportation order.
Yes.
So the question is whether in the process of means is considering getting on with the process, or whether it means has reached the end of the process and has decided but hasn't yet actually stamped it.
Well, in my submission, if it were the...
I mean, I know where you stand on this.
But
yes.
just to answer my lord's the proposition, if it meant the former, in my submission, one would expect it to say, in the process of considering making the subject of deportation.
Well, absolutely, but bearing in mind that we're not here considering a statute.
No, but
we've got to decide. It has very serious consequences.
Very serious consequences. It's received a high level of parliamentary
That's why
scrutiny.
you went through all those points
That's
at the
why I went through
beginning,
those
yes.
points.
But whatever it isn't actually a statutory
No,
instrument.
it's not.
It's
No.
attached to it, and it's definitely not primary legislation.
I've accepted all of that.
Right, now you were taking us here for another
I was
purpose.
taking, yes, exactly, for the third category. So I've submitted that the third category requires that the person was subject to deportation proceedings before they left the UK. Why does it matter that this happened before they left the UK? Why not include the situation where the person was made subject to deportation proceedings after they left the UK? And in my submission, the necessary implication is that the individual has been put on notice of the deportation proceedings and therefore knows that if they leave the UK, they may not be allowed back. And in my submission, that implication is bolstered by the House of Lords judgment in the case of Anna Frieva. If I could ask my Lords to turn that up, it's at tab 15. Same bundle, tab 15.
Yep.
The case concerned the proper interpretation of a piece of benefits legislation, which one sees recorded at the top of page 266. Very top of that page, it was a regulation which provided for the purposes of this paragraph, a person ceases to be an asylum seeker in the case of a claim for asylum, which on or after the 5th of February 1996 is recorded by the Secretary of State as having been determined, other than on appeal or abandoned, on the date on which it's so recorded. And the question was, it mattered because this affected when your entitlement to income support ended. And the question was, when was a claim recorded by the Secretary of State as having been determined? And the claim was in fact recorded as determined by an immigration official on the 20th of November 1999. Income support was then stopped on the 9th of December 1999, but the asylum decision wasn't communicated until some time later. And so the question was, did the right to income support stop when that internal record was made by the immigration official? And the majority of the House of Lords held, Lord Bingham dissenting, that the words recorded by the Secretary of State as having been determined had to be interpreted as meaning when the individual was notified. And Lord Steyn gave the leading judgment explaining why. Begins at page 272. And could I please begin by noting what's said at letter H, where Lord Steyn recorded that although the issue might appear technical, it may have a more general bearing on the development of public law.
Can I just check, were they arguing about the meaning of determined? Unless an internal note isn't a determination, it has to be something that's sent to that. So even though something was recorded, that which was recorded was not a determination.
Yes,
Is that the argument?
that's it.
Right, okay.
And the point I was just alighting on here at 272H is that the House of Lords were aware that what they were saying might have a more general bearing on the development of public law. Page 275. At paragraphs 26 and 27, Lord Steyn referred to the principle of legality. I'm not going to ask my Lords to look at that. But at paragraph 28...
That's the point that says it's the determination. It's not a determination unless you know about it.
But at paragraph 28, he turned to a separate point, leading to the same conclusion, which is the constitutional principle requiring the rule of law to be observed. And if you could please read the whole of paragraph 28. And then also overleaf, if you could please read the whole of paragraph 30. In my submission, that analysis also applies to category 3 in 14F of the ATC scheme. The requirement that the person was made subject to deportation proceedings before they left the UK could, in my submission, be understood to mean that the person was notified of the deportation proceedings, so that they could decide whether or not to travel abroad in light of that risk.
Well, at the moment, I can't see how it could be anything else, because the only if proceedings mean tribunal proceedings, they only apply if he appeals against the refusal of human rights claim.
My submission is that it's not limited in that way.
No, you say it goes further, so he's got to be notified by the Secretary of State of the bits of the proceedings that are the Secretary of State's decision making. That's
Yes,
your argument.
So
yes.
my submission is that category 3 bites at the stage 1 stage. So this letter that this appellant received triggered category 3, but only if he was in the UK when he received that notice.
Yeah, hold on. So it includes notification of I'll call it a decision, and that wasn't notified. The problem here is the decision was sent to the last known address.
After he left the country.
Yes, but that doesn't matter normally.
It does matter for category 3 in my submission.
He's got to have left before the proceedings are concluded.
Yes, that's what we go back to category 3.
Yeah.
Who were subject to deportation proceedings but left the UK before those proceedings concluded. It's implicit that they were subject to deportation proceedings before they left the UK. That's what that means.
Sorry, can we just look at that again?
Page 98 behind tab 8.
Where I'm getting confused now, Mr. Butler, just so you know, and it's my fault, proceedings on your analysis covers everything.
Yes.
And he's got to have left the United Kingdom before these proceedings were concluded. And he did.
Who were subject to deportation proceedings,
Yeah.
but left the UK before those proceedings concluded.
Yeah.
In my submission, it is a necessary component of that the person was subject to deportation proceedings before they left the UK.
And until the letter is on his desk telling him that,
He is not subject
he's
to
not
proceedings.
subject to it.
That's the submission I'm making.
So until he receives the letter, until he actually receives the letter?
Well, I don't need to go so far as to actual receipt.
Well, let me give you another example. He hasn't gone to Pakistan. He's gone to Scotland. Separate legal jurisdiction. They're different.
Not left the UK.
Exactly. So he's not in England. He's not even in Wales. He's in Scotland. He hasn't left the United Kingdom. The letter's been sent to his last known address. What's the position then?
Well, then he comes within 3.
He is within 3, even though he's never seen the letter and knows nothing about it.
If he's been given valid notice, and then the question might arise whether sending it to the last known address is sufficient.
Well, I was going to ask about that. I think you say, for reasons I understand, on the facts of this case, it doesn't matter. In other circumstances, it would be crucial, and that there must be rules. Well, there are often rules which say what constitutes valid service, and which often say 2-day ordinary course of post, last known address. Are there any such rules governing the service of a stage 1 notification? Almost certainly not, because the stage 1 notification is in fact it's not a statutory creature at all.
No, I will have to check, my lord. I think there is something to the effect of you've got to make, the Secretary of State's officials have got to make certain efforts to draw it to the individual's attention. which requires serving it at the last known address, and then if they don't get representations in response, checking whether the individual's received it or not. But I'll have to check the detail of that.
What happens to a person who walks out of prison, gets on a plane, and the Secretary of State has effectively no known address and so forth, no way of communicating? Does that mean that the AT scheme is disabled? So that if the Secretary of State is then told that this person is coming back at some imminent date, they can't do it because he hasn't had any notice of any of the 3 stages.
Two answers to that, if I may. The first is that I'm going to come on to show the court in due course that the way in which the process is supposed to work is that the individual gets served with the stage 1 decision in prison. It's only because things went wrong in this case that there was a delay.
Yes.
And so it's unlike that. The situation my Lord's described is unlikely to arise in practice if things operate as they should.
Yes.
But as a matter of principle, in answer to my Lord's question, there would be nothing to stop the Secretary of State going on to make the deportation order and thereby catching the individual through Category 1 or Category 2 of paragraph F, or, subject to my submissions on issue 4 and the court's conclusions on issue 4, there'd be nothing to stop the Secretary of State making an exclusion decision under paragraph E. So the Secretary of State wouldn't be disabled from applying the ATC scheme to that individual.
I was going to ask about whether there must be rules on service of a deportation order. There's got to be, because that really is a legal instrument which has effect, and it means it's a criminal offence to come back in with it. So there's got to be rules of service for that, I'd have thought.
Well,
and that may indicate in those rules whether any other stages have got to be notified, and it may indicate the very fact that you say the deportation order must be served might impliedly exclude the service of things leading up to the deportation order. So there's got to be something, somewhere, Mr. Butler. There used to be a little set of statutory instruments which gave last known address, last known business address, and so on. I don't know if that's still there and whether that applies.
I don't have an answer now. I will check as soon as I'm able. For my purposes in this appeal, it's enough to say that there's got to be effective notice, whatever that is.
At some stage, not now, I'd be interested to know if you have a way through this for your client, irrespective of the arguments about the means of categories 1, 2, and 3. One can see, some people might think there's an unfortunate, and some might say, obvious unfairness here. I don't know, I haven't thought about it enough. And I wonder if at some stage you're going to be telling us, even if you're wrong on this, there's still a way forward for your client, or whether it all hangs on this.
Article 8.
Oh, so it's Article 8 or stage 1 or bust then. Okay.
And when you say Article 8,
has the appeals been pleaded?
I don't want to anticipate. I don't want you to anticipate this point now, but why not just ordinary common law unfairness?
Well, yes. Why not? But
okay.
I'm stuck with the grounds as advanced and granted permission.
Yes, but they aren't as hopeless as you might think, because some of the words used don't help. Historic injustice, but what's the historic injustice? It's not historic actually, but you're saying there was an injustice here. You're saying through nobody's fault he'd gone abroad to see his ill father-in-law, and they served it on him without knowing. And I'm sure you'll want to show us that bit in the bundle that says, shall we serve it? Caseworker on holiday. What shall I do? Oh, serve it anyway. I'm sure you might want to say, even though the words used by your junior who's advancing a good case said historic injustice, injustice, which is unfairness, might be enough. I don't know if you're going to argue that at all.
I will think about that. Thank you.
Just in case you don't win on this one, I was thinking.
But can I just, forgive me for not having been keeping up. This is all directed to your submission that this is a Category 3 case. If it was a Category 2 case, the whole question of having of the date at which he left the proceeding, left the UK, and whether the proceedings had started by that date wouldn't get you anywhere.
No, but
why is it not a Category 2 case again?
Because I say that the process of making the subject of a deportation order means the process of making the deportation order, and you haven't reached that point at stage 1.
Yes, I see.
Because you don't know whether you're going to make a deportation order.
Yes, okay.
Yes, you're saying the process of making a deportation order can't include the consideration of do the exceptions apply, and if they do apply, should I nonetheless make the order?
Yeah.
That's your case, isn't it?
I see that. So you knock out Category 2 by that argument. You knock out Category 3, which uses different language, by this argument.
Yes.
I don't think you have shown us or told us anything about any relevant extraneous materials about the introduction of Category 3, which happened in 2013. Are you going to do that?
I'm not going to, no.
Because
I haven't been able to find anything.
right. There must have been, and I'm not saying we should be shown it or it would be admissible, but there must have been a debate in Parliament. But possibly not for this kind of pseudo-subordinate legislation, an explanatory note or memorandum.
No. I mean, there would have had to have been an affirmative resolution on the regulations bringing...
Yeah, the Minister would have to have presented the matter to, and might, since this was the only, well, there may have been other changes, but since this was a change from the ones which Parliament had approved in previous years, you might have expected to see some discussion of what the change was and why.
Yes. Well,
have you looked at that?
I haven't looked at Hansard, no. And I hope that those behind me have heard that and will do so.
All right.
Subject to the question of admissibility.
How are you proceeding? Because we're on the second submission on the first issue.
Yes, I should say that the first issue is going to occupy by far the largest share of my time, so I'm making reasonable progress. Just to finish off this submission on the third category of paragraph F, and my submission that it requires the individual to have been notified, whatever notice means. The alternative, no notice, would in my submission be strikingly unfair. If one takes a non-automatic deportation case, if category 3 doesn't imply a notice requirement, then an individual who has ILR, who's never committed a criminal offence, might go on holiday. The Secretary of State can then send them a stage 1 decision while they're away, and on that basis alone stop them ever returning, even though they'd have no way of foreseeing that risk.
Well, they do if they know they're a serious criminal.
No, in a non-automatic case.
Oh, not automatic. Yes, I see.
Which doesn't depend on criminal conviction.
Yeah.
Yes.
And then, if we might just finish off on, well, I can make the point. In Anno Frieva, paragraph 36, page 277, Lord Steyn said, well, the individual circumstances in this case evoke little sympathy, but that shouldn't detract from the point of principle. I also accept that my client's criminal history doesn't evoke sympathy, but this is a pure question of interpretation, which has to apply to the run of cases, some of which may evoke greater sympathy than mine. Can I then come back to the point that I've already touched on in response to my Lord Justice Jackson's question?
I'm just thinking, sorry, I know you want to go back. 2021, the previous scheme only had categories 1 and 2 under F.
Yes.
So on your analysis, the original scheme only intended the deportation order or the few minutes between yes, all the boxes are ticked, I'm about to sign the form. Those are the only two situations in which you could grant it. And you say there's nothing wrong with that. And the fact that they've widened it doesn't matter because they've widened it for a particular set of circumstances to do with implicit notice?
Yes. Well,
Yeah, okay, just so I fully understood.
they've widened it to draw in
A
cases
group of
at an
people
early
who
stage.
are meritorious in the sense that they knew they were facing deportation or run away.
Exactly.
Yeah. Sorry, yes, just to make sure I've got it.
Yes. So can I then return to the point that if the deportation process operates as it's supposed to, then almost all automatic deportation cases will be caught by Category 3. And could I show you this, please, in the guidance? It's tab 12 of the authorities, page 128. 1 to 8. And it only says what one would expect to happen anyway, but halfway down there's a paragraph which reads, all foreign nationals who receive a custodial sentence in the UK are referred by the relevant prison service to Foreign National Offenders Returns Command for deportation consideration.
I didn't do it here.
They didn't do it here, but in an automatic deportation case, what should happen is that the process starts while the individual's in prison. It should have happened while the appellant was in prison. He should have received the stage 1 decision letter while he was in prison.
No, it's not only cases of administrative error. For example, someone could have a short sentence, a year, and they could serve most of it on remand in any event, so they're released very shortly after the conviction.
I accept that.
That's not an uncommon situation.
I accept that, which is why I've said in most cases, not in all, but for administrative error.
Yeah.
Now, in our case, the appellant would then have been on notice of deportation proceedings, would have fallen within Category 3, and the evidence indicates that he would then never have gone abroad, given that he cut short his holiday and tried to return to the UK within 3 days of being served with the Stage 1 decision. So pulling together the threads of my submissions on 14F so far, I'm sure the court has it. Category 1 of 14F, the Secretary of State may refuse to authority to carry if a deportation order has been made. Category 2, if she's decided to make a deportation order.
That's the, I won't quite say scintilla temporis, but that's the very short time point.
Yes.
Yeah.
Category 3, she may refuse authority to carry at any stage of the deportation process, providing that the individual was notified before they left the UK. Could I then proceed?
Can I just ask one, can you think of a rational reason why Category 2 was thought necessary in the earlier versions of the scheme? It'd be an odd thing to provide for if that's all it meant.
Well, because the F is catching both automatic and non-automatic cases. And it is conceivable that there will be a gap in time between the Secretary of State's decision to deport and the making of the deportation order.
Well, why is that not true in case for both categories, automatic and non-automatic?
Well, I mean, in non-automatic cases, there's the possibility of an appeal.
Was that? Yes, but an order will have been made.
No, the order can't be made until the
Yes, I see.
appeal are exhausted.
Yes, okay.
And
No, okay, that's a good answer.
I just don't know how the Secretary of State's internal processes work as to whether or not there's a gap in time.
Well, there almost certainly will be a gap in time of some kind. But, well, in most administrative things, you'll probably find you look at the record, decided to make an order, and it's made the next day or the day after.
Yes.
But it's not something you'd normally think if you were drawing up a scheme that you'd make separate provision for cases falling within that gap.
No, I mean, in my submission, as originally drafted, it's a residual category. The core of F is there's a deportation order, but let's pull back slightly further in time from there and catch those cases in which we've decided but we haven't yet made the order.
It's the equivalent you submit of this order shall have effect notwithstanding that it doesn't bear the court seal.
That sort of thing, exactly.
Yeah.
Could I then please develop my third point, which is that we say our interpretation of 14F makes sense in light of the statutory framework for deportation, and two strands of that. First, the decision-making and appeal framework, and second, the detention framework. Now, the framework for deportation confers important procedural rights on the individual, and that includes the right to remain in the UK while making representations on the application of Section 33 exceptions in automatic cases.
Say that again, appeal.
The framework, the statutory framework for deportation confers important procedural rights.
Yeah.
And that includes the right to remain in the UK during any process of representations on the application of Section 33. I appreciate the Act doesn't say you've got a right to representations, but it's been given by the policy framework. You can stay in the UK while you make those representations. And then importantly...
And that's just the guidance there.
Yes. And then importantly, there is an in-country right to appeal against the decision, well, not the decision to deport, an in-country right to appeal against a conclusion that Exception 1 doesn't apply.
Well, there's a right to appeal against the refusal of a human rights case,
Yes.
which will, in effect, overlap with you.
Yes, exactly. But that, in my submission, is an important procedural right. And a refusal of authority to carry short-circuits the entire deportation process, including the right of appeal. As in our case, if the individual is kept out of the UK through an ATC refusal, the Secretary of State may consider that she doesn't need to complete the deportation process. She may instead make an exclusion decision. And on the Secretary of State's case, an exclusion decision doesn't generate a right of appeal at all.
Even if they make a human rights claim. But that can't, can it be right because it's Section 113? Anyway, that's not for you, that's for them.
That's the Secretary of State's case. I mean, as it happens, the tribunal has concluded that the appellant has a right of appeal, and an appeal is being advanced in the tribunal against the exclusion decision on human rights grounds.
Oh, sorry.
But apart from that, although we say that there is a right of appeal, it's an attenuated right. The appeal has to be brought out of country, and it's limited to ECHR grounds. It can't be brought on Refugee Convention grounds. If I could just show you that, it's tab 4. Page 61. Section 92, subsection 2, a protection claim, that is a refugee appeal, must be brought from within the UK. You can't do that if you've been refused re-entry.
I'm really, really sorry. I'm looking at page 61, I'm looking at 92. I'm looking at what, subsection 2 in the case of an appeal.
In the case of an appeal under 821A, which is a protection claim appeal, the appeal must be brought from outside the UK if you've been certified, which is not this case, which wouldn't be this case.
Okay, right.
Otherwise, the appeal must be brought from within the UK. You can't do that if you've been refused entry under the ATC scheme. And so, just to give an example, if you've fled from Russia to the UK, you've been granted ILR, and you then go on holiday to India, which isn't a signatory to the Refugee Convention, then the effect of an ATC decision may be the loss of a Refugee Convention claim. And then the other attenuation is section 92, subsection 4, which provides for an appeal on ECHR grounds, but that's out of country if you're outside the UK. And in my submission, the loss of an in-country right of appeal and the loss of a potential appeal on refugee convention grounds is potentially serious. Now, on the loss
might that not lead to a decision in an individual case?
I'm so sorry.
Might that not lead to a decision in an individual case not to make an ATC direction? I mean, there are two practical issues, obviously. One is what the scope of the scheme is, and the other is whether it's appropriate to make the direction in the individual case.
And of course, I'm just advancing this point
Of course,
of the
yes.
scope of the scheme.
Yes,
I
understand.
accept my Lord's point that the Secretary of State isn't mandated to make an ATC decision.
And he isn't. She may.
Exactly.
I mean, she's got a discretion.
Exactly.
Yes, this is my point.
Yeah, and the question is, here, why didn't she think about that?
Yes, but we'll come to that.
Yeah.
Could I just say something about the loss of an in-country right of appeal by reference to the Supreme Court's judgment in Chiari and Bindlos? This is Authority tab 26, which is the second of the bundles.
Which tab did you say?
26 begins at page 474.
Yeah.
And as the court will know, the case concerned the impact of being required to bring a human rights appeal against deportation from abroad, pursuant to section 94 capital B of the 2002 Act. And the Supreme Court identified that being kept out of the UK would potentially bear on an appeal in two ways. First, it would damage the individual's relationships with his family, pending the appeal, thereby weakening the substance of his Article 8 claim by the time the appeal was heard. One sees that at page 494. Paragraph 57.
Yes.
And then 2 lines below letter C, no doubt the tribunal will be alert to remind itself of its duty to set aside the deportation order and thus to enable the appellant to re-enter the UK if his human rights were so to require. But by reason of his deportation pursuant to a certificate, his human rights are less likely so to require. It's one thing further to weaken an appeal which can already be seen to be clearly unfounded. It's quite another significantly to weaken an arguable appeal, such as a step which calls for considerable justification. And the same in my submission can be said about an ATC decision under 14F. It short-circuits deportation, separates the individual from his family, and thereby weakens any Article 8 appeal against a later exclusion decision. Second point, there may be formidable practical difficulties in mounting an appeal from abroad. And could I please highlight 3 points? The first is potential difficulty of communication with lawyers, page 495, letter B. Even if an appellant abroad secured legal representation from one source or another, he and his lawyer would face formidable difficulties in giving and receiving instructions, both prior to the hearing and in particular, as I'll explain, during the hearing.
But that can't really, in the modern world, and given the experience of this case, be relevant here. He's conducted an appeal in the High Court and the Court of Appeal. His wife and family are here. He's in regular communication with them.
I'm not making the submission,
Generally.
that submission in relation to this individual. I'm making the point in relation to the interpretation of the scheme. There will be cases where it's still difficult.
Yeah.
Second point, giving oral evidence, if you please note what's said at paragraph 61.
These issues about, you know the answer to this, but issues about notification, which you were recently discussing, I mean, they came up, didn't they, in deprivation of citizenship cases, and whether notification had to be given of those. Issues about the ability to come and give oral evidence very definitely arose in the Begum litigation. So I just want to check that what you're showing us here are the last word on these matters, or whether there is some transferable learning from later decisions?
Well, I've not focused on the bit of the decision which deals with the difficulties of setting up video links in the tribunal and setting up video links from abroad, because things have moved on in relation to that. But the bits of this judgment that I'm showing the court in relation to damaging the Article 8 claim, potential difficulties corresponding with lawyers, potential difficulties with giving oral evidence, those still apply. Whether or not they arise in a particular case will depend on the individual circumstances, will depend on the country in which they're present. But I'm just making the point at a level of generality.
These are relevant matters.
Relevant matters to the interpretation of the scheme. And then the permission of the other state must be sought if you're going to give evidence from abroad. Now, I don't propose to turn it up, but we've got an authority on that as well.
Akbar Biaka.
Exactly. And states like Pakistan may simply not give permission. And then page 499, paragraph 74, Lord Wilson makes the point that expert evidence may be worthless if the individual has been unable to see the individual in person. He says that may be the case in relation to psychiatric evidence. It may be the case in respect of social work evidence on the relationship between the parents.
Which paragraph was that?
Paragraph 74, page 499.
Yep.
Now, in my submission, that's all I wanted to show the court in my submission, before shutting up the individual and short-circuiting the deportation process, fairness calls for the individual to be notified that the deportation process has commenced. Now, our reading of 14F secures that. If the individual has received notice of the deportation proceedings and chooses to leave the country, well, that's on him. That's akin to an appeal being treated as abandoned if the person leaves the UK. Section 92, subsection 8 of the 2002 Act. But if the individual hasn't been notified, then in my submission, fairness requires that he be allowed back to see through the deportation proceedings. And could I perhaps put down, given a limited time that I have available, could I perhaps put down a marker that, having made that submission in relation to the interpretation of the scheme, could I please also advance that same submission in relation to the particular facts of this case in relation to issue 3, without having to repeat myself on these points?
Cross off the word historic and say injustice.
Exactly.
Yeah. And although it's not, it's clumsily put, it's working into speed, they never considered this.
Exactly.
Yeah.
So I hope the court then has my submission, at least in outline form, on that point too.
Yeah.
Now, the other point I wanted to make about the statutory framework is that Parliament has enacted a specific scheme to protect the public pending the conclusion of the deportation process. And that's the statutory scheme for detaining or imposing bail conditions on potential deportees.
Is this submission 4?
This is all part of the third.
Okay.
In relation to detention, I've included section 36 of the UK Borders Act in the additional bundle of authorities that I handed up this morning. And I would observe that that power of detention doesn't depend on serving even a stage 1 decision. And then in relation to bail, it's Schedule 10 to the Immigration Act 2016, which is also in that bundle. And as the court will know, that includes the power to impose an electronic tagging condition. And so in my submission, it is unnecessary to read 14F of the ATC scheme in an expansive way so as to ensure effective protection of the public pending the conclusion of deportation proceedings. There's already a scheme for doing that. Then finally, on issue 1, my fourth point, which relates to paragraph 14E of the scheme. Now, could I briefly please look at the facts that are relevant to that point, starting in the supplementary bundle at page 136. And one can see that on the 20th of January 2025, the Secretary of State wrote to the appellant solicitors and invited representations before she considered making an exclusion decision. And then in the core bundle, page 274, it was on the 13th of June 2025 that the appellant was notified that the Secretary of State had made an exclusion direction. So with that sequence in mind, could we please turn up the 2021 scheme, or we can do it in the 2023 scheme, just keeping in mind the slight differences between the two.
Where did we find the 21 scheme?
21 scheme is in the bundle I handed up this morning, behind tab 3, at page 81.
Remind me why we're looking at the 21 scheme.
The submission I'm going to make is that the Secretary of State gave guidance on what E in this scheme means, and that Parliament would have can be taken to have been aware of what the Secretary of State said
Right,
about
so
the
it's
meaning.
because there's no guidance in the 2023 scheme.
No, but it's more than that. It's that Parliament, when promulgating or when approving...
Yes, I understand the point, but
Yes.
if the guidance had been given in the 23 scheme, we'd be going there. You're
No,
only going there because it is...
we wouldn't be going to it in the 23 scheme, and the reason being that my submission is that what matters is what Parliament would have understood E to mean when it made the 23 scheme. And what it would have understood E to mean would be informed by what the Secretary of State said E meant in the 2021
Right. So what
scheme.
page are we at in the new
So
bundle?
it's just to show the court that at page 81, paragraph E is in the same terms.
Oh, I see, sorry.
81. Yes.
So as you say, we could actually
You could
done it from the 33 scheme, but it doesn't matter. Yeah.
Exactly. And the question that I'm concerned with is that at what stage of the exclusion process, which we've just looked at on the facts of our case, at what stage of that process is the Secretary of State in the process of making a decision that the individual be excluded from the UK? Did it start before the Secretary of State notified the appellant on the 20th of January? Did it start when the Secretary of State notified the appellant on the 20th of January? Or was it when the matter was put to the Secretary of State in June? So what does the Secretary of State's guidance say about that? That's in the same bundle that we've got open, behind tab 5. At page 122. So there should be a heading there, Authority to Carry Scheme 2021. And then just below the first hole punch, there's a paragraph beginning, where a full submission has been made. If you could please read that paragraph. And so according to this, the process of making a decision to exclude didn't apply to the notification stage or the representation stage.
I'm sorry, you tell me whether I misunderstood this. I have had it lodged in my mind that the exclusion is one of those rare things, wherever the power comes from, which must be exercised personally by the Secretary of State.
Yes.
So when you see a Rule E saying excluded by the Secretary of State, it's one of those rare things when you've got to remember it's the Secretary of State who will have excluded. There wouldn't be anybody else doing it. And in relation to whom the Secretary of State herself is in the process of making a decision.
Yes. But what the point I'm making, the significance of this for my purposes, is that the process of making a decision to exclude within the meaning of 14E doesn't apply to the notification stage, which is analogous to the stage 1 process in deportation proceedings, nor did it apply to the civil servant's consideration of the representations.
How do we know it doesn't apply? Well, how do we know there is a notification stage?
Because I've shown how that happened in our case.
But you haven't shown us anything that says that's what should have happened either
No.
under the law or under the guidance. It just so happens that in your case...
In our case, it did. And so on the facts of our case, E didn't apply at the stage of notification, according to the guidance.
Isn't a slight difficulty that deportation has built into it, as you've shown us very elaborately, a two-stage process. Exclusion doesn't.
May or may not.
Not surprisingly, as an interest of ordinary fairness, they did in this case, and I'd be surprised if they didn't generally, give you the opportunity to say why you shouldn't be excluded.
Yes.
But I'm not sure you can map that onto the processes followed in F.
Well, that's the submission I was
Yeah.
going to attempt to advance.
And also, I do think exclusion may be different. I don't know. I get the sense if it's people who are really risky threats, you're not going to ring up a major terrorist chief and say, I'm terribly sorry, but I'm thinking of excluding you. Is that all right with you?
Well, if you're a major
You may
terrorist threat,
well
you'll be
have to
caught by
make it
something else.
before you tell him. So
Well,
it doesn't look like an analogous situation.
I accept that there will be cases, maybe cases, in which there won't be notification, there won't be a right to make representations in an exclusion case. I accept that.
Yes.
The submission I'm making is that in some cases there will be, and in those cases, E doesn't bite until the matter is put before the Secretary of State.
Right.
And in my submission, this gives some indication of how Parliament would have understood the same words in paragraph E when it approved the 2023 scheme. And it also gives an indication in my submission of how Parliament would have understood category 2 of paragraph F
Yes.
of the 2023 scheme. And one might think that the reason that Parliament expanded the scope of paragraph F in the 2023 scheme was so that authority to carry could be refused at an earlier stage of the process.
Where notice had been given. As you
Where
put
notice
it.
had been given,
Yes.
but before a decision had been made. Looked at another way, if the process of making a deportation order covered the same ground as deportation proceedings in category 3, then the introduction of category 3 was pointless. Now, those are my submissions on issue 1. I'm going to be much quicker on the remaining
Well,
issues.
if you're content that you're in a good place, then so are we.
Is it convenient for me to embark on Article
No.
8, or shall I break it up?
No. Let's do that at 2 o'clock.
Thank you.
All right. Thank you.
Court arrives able.